Hello and welcome to Legally Speaking with me, Tarun Nangia. From July 1, 2024, the three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, Bharatiya Sakshya Adhiniyam were enforced. We all know Home Minister Amit Shah introduced these bills in Parliament, which were then turned into law. And these new criminal laws mark a significant step towards empowering the Indian citizen, and these laws are in a sense being made to create a more accessible justice system which is supportive and efficient. All of this and more we are going to discuss today, that how these three laws aim to take the criminal justice system to the 21st century, and with what intent these laws have been made after the Britishers that made these laws post 1857, and now they have been in a sense modernized to reflect the realities of today. But I'm not an expert on this. My guest today, Senior Advocate Sanjay Jain, will share his insights and views on this. Good to see you, sir, and thank you so much for your time.
Thank you, Tarun, for inviting me here.
And I want to ask you that Home Minister Amit Shah introduced these laws in Parliament and at length spoke on them, and how these laws have been, in a sense, made to reflect the realities of the day. And there was a need, for example, he spoke about how DNA, in a sense, evidence will also be used for, in a sense, investigating crimes. And this is what the modern DNA evidence did not exist in 1857 when the Indian Penal Code was written. So many things have been introduced. May I request you that in the first few minutes, if you could, in a sense, talk about the vision, mission, and what intent these laws have been framed, and what is the impact? Over to you.
Yes. In fact, there is a complete transformation. A colonial regime being replaced by our indigenous regime is in itself a matter of great celebration. We have waited for about 75 years post-independence for this development to happen, and the credit goes to our Home Minister that he was steadfast and very firm, and he acted with conviction when he saw to it that these three laws are passed. And it is not that these three laws have been passed without any discussion. I do remember that on several occasions at several forums, even I was called as a speaker to speak in the deliberation process. So these three laws have undergone those deliberation process, which ought to be preceding such a hugely transformative legal regime. Now, as you rightly pointed out, that so far as Indian Penal Code is concerned, it was lying ready with Britishers. Lord Macaulay had drafted it in 1840s, and it is only after mutiny that Britishers thought of it that these natives need to be taught a lesson, and there we need to have a penal code. And then they brought an Evidence Act, and then they brought a criminal procedure, several versions of them within a short span of time. The main issue is you have to understand it from the perspective. What is the mindset? The mindset of the British regime was to keep the Indians in reign, in check, and to teach them a lesson and to punish them for any delinquencies or irregularities or the offenses that in their perception we Indians were prone to commit or were committing. Juxtaposed to that, when you are an independent country, the ethos of a criminal system is to regulate a society from the perspective of justice, so that the citizens get justice, and any citizen who is a victim, he is able to get justice at the quickest possible time. And how does a citizen get justice? A citizen is likely to get justice when his complaint is acted upon in a rapid manner. It is investigated with the scientific techniques which are contemporaneously available. These are the situations which also require a balancing of his emotions. So therefore, there has to be a law with regard to the witness protection. There has to be law which thinks about the victim. There has to be a constant interaction between the investigating agencies and the complainant who is normally a victim. So these things have been brought in by these laws, the three laws which our Honorable Home Minister has introduced. So if I were to describe the plight of a common person in this country under the old British laws, I can describe it in Dushyant Kumar's two-line couplet कि ये जिस्म झुक कर बोझ से दोहरा हुआ होगा, ये जिस्म झुक कर बोझ से दोहरा हुआ होगा, मैं सजदे में नहीं था आपको धोखा हुआ होगा. So our population was just lying flat before the system, and different people would interpret, no, this is not a real pain or pathos of this person, it is his normal condition. No, it was not our normal condition. We were actually in pain. We were in pain, the citizen was in pain because his complaint was not being listened to, addressed or redressed. It was not scientifically investigated and he was not getting justice. So that is the uppermost and the most centerpiece point of the whole system, justice delivery system, is that the justice is secured to the citizen. So these three laws, fortunately, have brought a fresh whiff of air and a freshness and a new approach. And that new approach ensures that a citizen has a voice. Now an investigating officer has to constantly keep informing the victim as to what progress has he made in the investigation. There has to be a video recording of the crime scene. There has to be a scientific forensic examination. All these years we had a very limited number of forensic laboratories in this country. Now these laws will compel the state, because law and order and police under the constitution is a state subject. So it is a time for, it's a wake up call for all the states also, that they augment their legal machinery and help the central government in bringing a revolution in this regard, because ultimately whether it is a central government or a state governments, they all have to work for the welfare of the population of this country. So initiative has been taken by the central government, but to a large extent its success will depend as to how the states react to it and they gear themselves up. So of course, so far as center's preparedness in this regard is concerned, that can be gauged from the upgradation which may happen in the union territories. But for other states also, it is a time, as I said, it's a wake-up call, and it is a wake-up call which is very welcome. So coming back to the basic point, ultimately in any justice delivery system, the unnecessary bottlenecks had to be removed. So those bottlenecks have been removed. In Evidence Act, for instance, there were so many bottlenecks that it was, we were always as a lawyer struggling between primary evidence, secondary evidence, proving a photocopy, bringing a carbon copy, all these things. I mean, for longest of time, we refused to believe that there is no need for a carbon copy and the photocopy is enough. For longest of time, we kept on insisting on the actual signatures and ignoring digital signatures. So for the longest of time, we forgot that this document has originated from in the electronic form from the computer system of somebody, and it has been exchanged by way of email, and these mails etc. do not actually require any signature. So therefore not every contract requires a proper signature as it was in the conventional regime. So that is one aspect. Another, this is in the domain of the contract or the civil law. In the domain of criminal law, CRPC etc., if you see, we had been following archaic system where by its very nature the investigation was bound to be lethargic, because it was too much human centric, in the sense that investigating officers IQ level, investigating officers experience level and his understanding was the key factor in the success or failure of an investigation. Now these things are not left under the new system and under the new regime, these things will be addressed in a scientific manner, with a forensic evidence, with a videographed scenario being available to the investigator. So the quality of investigation will increase. The perception with regard to the victim will also be different now. We have seen how our women folk in this country, despite being the victim, were always shamed, and they were chased and hunted. And it's not that these things are completely over, but these laws are only not less than, they are less than 2 months old. So we have to give them time. It's very early to be judgmental about them. But I am very confident that this initiative of our Home Minister, Mr. Amit Shah, will bring a new kind of an ecosystem in the justice delivery system. And this you will realize in many ways, because as I mentioned, the most important thing is the perspective of a victim. So if victim is getting compensation, victim is getting the redressal of his or her grievance, or the torture or the crime that has been faced by her or him. And second, immediately after that, because we are always very enamored and very happy to see the scenario in the big cities. But when you go to these smaller places, in the villages, it is not always that the victim, so-called victim, is correct. There are the cases where innocent people, poor people, are being framed. So it is equally important to see that the accused persons also get justice. And towards that also, this particular regime is very sympathetic and very conducive. Here, for instance, now an under trial can be released only after 1/3 of the total punishment. Earlier it was 50%. Now it is 1/3. And only yesterday, Honorable Supreme Court has said that there is no need to read this socially positive provision in a sense of only prospective application. We should actually treat it as a provision which is applicable retrospectively. So this judgment of Supreme Court, or this observation of Supreme Court, that this provision should be read retrospectively, that is section 479 of BNSS, is a greatest compliment which has come from the Supreme Court vis-a-vis as regards this law, this BNSS, that it has realized, and it says that if it is such a balancing provision that an under trial who is facing trial and is still in jail has to wait for 50% of his possible prospective punishment time and remain in jail without bail. So that has been reduced. So these are some of the steps, and we can go on discussing in detail.
In fact,
but I have given you a preface.
Now that you have given us a sort of a view into where these laws are headed and what all is being introduced, let us hear our Home Minister Shri Amit Shah on this issue, so you can make a sense of what he spoke in Parliament when these laws were introduced.
मान्यवर, विक्टिम को आज तक एफआईआर की निःशुल्क कॉपी की व्यवस्था नहीं थी, हमने कर दी है। विक्टिम को 90 दिन में जांच की प्रगति के बारे में कहा जाएगा। पीड़ितों को पुलिस की रिपोर्ट, एफआईआर और गवाह के बयान ऑनलाइन कंपलसरी भेजने का प्रोविजन किया है, और जांच और मुकदमे के विविध चरणों को भी ऑनलाइन पीड़ित को बताना। और एक कानून मान्यवर विक्टिम सेंट्रिक कानून बना है। पहले के कानून में जो अपराध करता है उसको दंड देने का उद्देश्य था। इस कानून का उद्देश्य जो विक्टिम है उसको न्याय देने का, उसके आत्मसम्मान को, उसकी गरिमा को पुनः प्रस्तापित करने का।
So you heard Mr. Amit Shah, what he spoke on these laws. Now let's go back to senior advocate Sanjay Jain. There is a new push towards digitization in these new 3 criminal laws. What I can read is reporting incidents online, that a person can now report incidents online, and FIR can be filed at any police station. Can you explain what is this to the common man?
Yes, it has a great significance for common man, and in fact, I would say that it has been possible to pass these laws only after our leadership was able to identify where the fault lies, where the flow was being obstructed. Again, to quote Dushyant Kumar in his Sai Mein Dhoop, there is two line couplet. यहाँ तक आते आते सूख जाती हैं कई नदियाँ, यहाँ तक आते आते सूख जाती हैं कई नदियाँ, मुझे मालूम है पानी कहाँ ठहरा हुआ होगा. So the leadership identified कि पानी कहाँ ठहरा हुआ होगा, where was the bottleneck, और उस ठहरे हुए पानी को बहाव में लाना, to bring it in the mainstream, was a challenge, and this challenge was very efficiently picked up by the leadership under the Home Minister, and he was able to get these 3 laws passed. And this is a transformation that I am talking about, that the bottlenecks will now be removed and there will be free flow of the system in the organic manner. And when I say organic manner, it starts with my in the criminal law, it starts with the registration of FIR. So if FIR is digitally registered, available to the citizen, he knows that whatever his complaint was has been reduced into writing. This used to be the greatest challenge in this country. In the earlier regime, I will go with my written complaint. That complaint, in the ordinary language, we would say FIR, but it was not an FIR. It was taken up only as a daily diary entry. And thereafter, it was left to the discretion of the police as to whether to convert that into FIR or not. Now, there are n number of Supreme Court judgments which will actually be more implementable under the new regime, where the complaint of a victim or a complainant will be registered digitally, and he doesn't have to go to the jurisdictional police station to get it done. There used to be a concept of zero FIR, which was mostly judicially recognized, but now it has got a sanctity of a statutory provision. Now, under the new statutory provision, it is possible for a victim to go to any police station and lodge his or her complaint, her grievance. And thereafter, it is the responsibility of that police station to make the basic preliminary inquiry and see to it which is the jurisdictional police station where this crime can be, or this offense or allegation can be properly investigated, and transfer it there. And further, if it is also possible now that the police station where this zero FIR or the FIR without territorial jurisdiction is being lodged, if that person feels that there is an immediate action to be taken in order to prevent further mischief happening, or in furtherance of in order to stop what was complained of, then it is possible for some remedial actions to be taken, irrespective of the fact that that police station doesn't have the territorial jurisdiction. So this is a great improvement from the earlier system. And if you think it from the point of view of a poor victim who doesn't have resources, who is already smarting under the pressure of being victimized, and who is harassed or who has suffered, and his suffering would have been augmented manifold if he had to run to first find a place, identify a place where his complaint will be taken up as an FIR, and when it will be investigated, if at all it will be investigated. So all those uncertainties in the system have been taken care of. All these unnecessary creases have been ironed out, and a smooth system has been substituted.
Point well taken. Thank you for explaining the FIR registration process. Now let us hear what Home Minister Amit Shah said in Parliament on these three new laws.
मान्यवर, पहले आप जानते हो पब्लिक प्रोसिक्यूटर ही आर्ग्यू कर सकता था, अब विक्टिम का वकील भी आर्ग्यू कर पाएगा। इंफॉर्मेशन का अधिकार भी हमने दिया है, नुकसान की क्षतिपूर्ति का दावा करने का अधिकार भी दिया है, वो भी क्रिमिनल कोर्ट ही तय करेगी, सिविल दावा नहीं होगा। 0 FIR से देश भर में कहीं पर भी कोई दबंगों के डर से वो थाने में अगर कोई मिली भगत वाला अधिकारी बैठा है, FIR नहीं लेता है, तो ऑनलाइन FIR देश भर में कहीं से भी वो कर सकता है। CRPC की धारा 321 में एक कमी थी, विक्टिम की बात सुनने की अनुमति नहीं थी, अब उसको सुना जाएगा, एक प्रति निःशुल्क दे दी जाएगी, और जब किसी के यहाँ भी जब्ती होगी तो कंपलसरी इसकी वीडियोग्राफी की गई है, जिससे पुलिस कोई चीज बाहर रख, पंचों की उपस्थिति में वीडियोग्राफी होगी जो सर्टिफाइड होगी, जिससे कोई किसी के घर पर कोई चीज रखकर परेशान किसी भी नागरिक को होना न पड़े। मान्यवर, ढेर सारे छिद्र जो थे, जो उसको बंद करने का काम नरेंद्र मोदी सरकार ने किया है, जो बिल लेकर आया हूँ।
So you saw what Home Minister Amit Shah said on these three new laws regarding varied aspects. Now we'll go to Senior Advocate Sanjay Jain to understand some more aspects of these laws. There is this aspect about the right to inform, that once you're arrested, these laws give you a right to inform anybody. What is this right that you have?
You see, right to inform is that when a person is arrested, then there is a concept of drawing a memo of arrest. The memo of arrest records some basic aspects like what was the complaint under, and that complaint has been perceived by the investigating agency under what provisions of law, and what is the summary, in the sense that what the reason why his custodial interrogation is required, or why he needs to be arrested otherwise. So that is a memo of arrest. It was there in the earlier regime also, but under the new regime, it is there is a possibility of making it more scientific and ensuring that every police station is compelled, and every police station is obligated to serve this this memo of arrest to the immediate family member or the
They know
person,
that he's been arrested and what to do.
So that they know, for three reasons. One, if at all the police is seeking a remand, then to contest the remand, also to seek the bail, and also to present his point of view, and to know as to what exactly is the charge against that person. Now, in addition to the memo of arrest, the police also has to give something called grounds of arrest. Now, the grounds of arrest are individual centric. Now, memo of arrest can be generic, that it can be relatable only to the complaint. Now, in complaint there may be n number of people involved, but ground of arrest is pertaining to each and every individual who is arrested, because it doesn't always happen that there is a complaint and only one person is involved. In most of the complaints, there are more than one person who are there. So the grounds of arrest have to be served separately on each and every person, telling what is his role or her role in that. So this is partly, what I'm saying is that, of course, so Honorable Supreme Court had passed various judgments to this effect that it should be there, but the regime earlier was not conducive to it. There was a mismatch. Supreme Court wanted these things to happen in this particular manner, but it was not always possible to have these things happen in that particular manner. Now, under the new regime, this desire of Supreme Court that the person who is arrested his family members and he should know as to on what basis he has been arrested, what is the case against him, and he should be informed about it immediately after the arrest as soon as possible, which was also the mandate of Article 22 of the Constitution of India. So that being the situation, these laws have brought the legal regime more in tune with the constitutional provisions.
Thank you for explaining that to us. Now there are two more things: fast track investigations that these three new criminal laws are putting into effect, and progress of update of case to the victims. Can you explain what this is about?
Fast track investigation is that depending upon the sensitivity of the crime, the nature of the crime, the immediately the police will get into action, because earlier also there has been this Lalita Kumari judgment which used to obligate police to act fast and register the FIR, which wherever there is a case made out, to register an FIR and to start investigation. But still there were too many slips between cup and lips.
Yes.
But now those things have been filled up.
So in case of a crime against women, they are saying 2 months is in the time limit in which you have to. Second thing which I was also reading is progress update to victims, that you update on investigations.
Though of course, if I were to speak as a spokesperson of the prosecuting agency, it is an added burden.
Yes.
But it is a citizen-friendly burden.
Yes.
Now the investigating officer is obligated to keep informing the complainant as to what is the progress that he has made.
Okay.
Now in my professional view, it doesn't mean that he has to disclose the complainant the entire investigation, because investigation is very sacrosanct.
Yes.
Till such time the charge sheet is filed.
Yes.
The investigation is not supposed to be revealed. Even the courts do not insist that you tell us what is your investigation. But broad features of the progress that the police has been able to make,
yes,
those broad features will be communicated to the victim or the complainant,
okay,
say at the interval of 2 to 3 months.
And it also says, and I can read out that in case of crime against women, children, investigation has to be completed in 2 months of recording information.
Yes.
So is this a sort of
earlier? It is I would say it's a historic move, and it is a very welcome move, because the investigative lethargy would lead to the destruction of evidence, and more than that, it would play havoc with the psychology of the woman victim. If you sit over an investigation for say 6 months, the kind of emotional trauma the woman victim would face, she may even decide to give up the complaint, or there have been so many cases of women committing suicide, etc. So any crime against woman or child needs to be put on the fast track from the day one. It has to be solved on yesterday basis. And how do you solve it? How do you resolve it? How do you investigate it? Unless you have the recording to the extent it is possible, and then immediately followed by forensic examination of the evidence available, and also to collate and compile all possible material in the quickest possible time, so that the charge sheet can be filed in good time without wasting time, and the trial can be fast tracked, because the time each day which is lost in these kind of crimes actually leads to the acquittal of the accused for various factors.
So 3 more things that we wish to discuss. One is the issue of electronic summons and statements by women magistrate, that for certain offences against women, statements of the victim are to be recorded as far as practicable by a woman magistrate. Third is supply of police report and other documents within 14 days. Can you explain these 3 concepts?
Yeah, the first thing is that what happens is that any statement recorded by police before police is has a very low evidentiary value. It has to be corroborated.
Yes.
So it is very important that the victim of a crime, if it happens to be a woman or a child, the statement is recorded by a judicial officer.
Yes.
At the earliest.
Yes.
And that lends kind of a credibility, because the statement which is recorded, say within 24 hours or as soon as possible situation, has a potential of being more truthful, because there is a lesser chances or possibility of the same being improved to frame somebody. So its purity is greater. So from the overall perspective, if when you register a case, you have to see that ultimately the guilty is punished, and to have the guilty punished, you have to assist the judiciary in arriving at the decision. So therefore, in that regard, this development of the woman officer recording. And why woman officer? Because in our country, still, if you have to see our society's background, still in villages, women are very shy and very apprehensive of speaking or breaking the ice with a person of another gender. So therefore, they will be more comfortable when speaking to a woman officer.
Point.
So that and even for a child, because mother or a woman in our system, in our Indian system, is an epitome of compassion.
Yes.
So there is an inherent presumption that if a woman officer is recording something, she will be compassionate, and she will be objective.
Right. So you saw Senior Advocate Sanjay Jain just before they explained us about statements made before a woman magistrate, then supply of police report and other documents. Now we'll ask him about the whole concept of electronic summons. So sir, could you tell us about the whole thing, that how is electronic summons taking us into the 21st century? Are summons sent by WhatsApp or email? What is going to happen with the summons?
See, it is revolutionary, and it is very, very justice friendly.
Yeah.
The earlier regime, the greatest challenge for a litigant and the advocates was to serve the other party. The greatest challenge for the police, the investigating agency, was to serve the persons whom they want to bring as witnesses.
Okay.
Because the mode of service was that either a constable will go
to the house,
to the residence of the person, and he would try to get hold of that person. They were like, suppose there is a woman witness, it had to be in the daytime, it could not be in the
evening hours,
after sunset. And also in relation to the male witnesses also, you see the Indian condition, it's a very it's not really possible in the ordinary course that a man who is working would be available after 8 o'clock. So people have to travel 2 hours to reach their place of work, and by the time they come back, it is 8 o'clock or so. So it was virtually a nightmare for the police people to serve the people whom they wanted to be brought before the court to make the statement. That is one. The same situation was with regard to serving the accused persons. In those cases where their arrest was not required, but they need to be brought either for investigation or other purposes. And if you go in another regime, in the contractual regime, in the civil regime also, serving the opposite party was the greatest challenge. So in that context, this system of electronic summon is a game changer.
So is it WhatsApp or email?
It is a combination of everything.
So physical will also be given, WhatsApp, email, everything.
Yeah, it is a bouquet of all modes. It is a service by all modes. Now all modes may include that even in the traditional system, the process server or a policeman can go, but then the court doesn't have to wait or rely only on that mode of service.
Okay.
Now today, if it is possible to serve it through WhatsApp, it is good enough. If it is possible to serve it through a mail, it is good enough. If you are able to serve it directly by sending, say, a speed post or a courier, etc., it is good enough. In the earlier system, one had to send it by a registered prepaid post.
So we are now
with
moving
acknowledgement due, and unless the acknowledgement due would come, it will not be deemed as a service.
Okay, so now we have moved into the 21st century as far as this is concerned. Yes. The whole issue of limited adjournments, yes. If you could explain to us.
Yes, limited adjournments is that, you see, first of all, adjournments are a sort of antithesis of any legal system which is aiming to give a quick and rapid justice. So fast track justice will be an illusion or a dream if the adjournments are not curtailed. So that is why this system or this concept of limited adjournments has been introduced. That the adjournments would be only if there is something unavoidable, extraordinary situation which absolutely obstructs the progress of that case on that day. Barring those exceptional circumstances, there would be no adjournments, and this also has to be seen in the context of the lawyers not appearing in the court. That is why the courts are now deprecating that no, there is no question of lawyers going on strike, because when the lawyers go on strike, there is a litigant who suffers because his evidence is not recorded there on that day.
As I read it, it says that courts grant a maximum of 2 adjournments to avoid unnecessary delays in case hearings, ensure timely justice delivery. So you mean courts can only grant 2 adjournments?
No, it doesn't mean that the courts can grant only 2 adjournments. I'm glad that you asked this question. It is not that the courts would grant, I mean, they are bound to, it is not something it's like a mandate. It is directory, it is not mandatory. But then the courts have to use their greater discretion. The adjournments are not there merely for asking. Earlier it
so
was,
the courts have
to apply their mind. They will use their conscience and see that if in a given case it is all right, but where it is justified. Unjustified adjournments, the ethos is that no unjustified
adjournment. So laws are curbing on that, so people are not troubled. Because one more thing is the exemption from going to police station.
Exemption from going to police station is that for things which can be communicated by, say, video conferencing.
Yes.
Then to that extent, for every time suppose a person has got a bail and the condition is that he has to go to he has to report to the police station. So it is possible to report to the police station even through EC. So that is.
And now they are also adding this, as I read, women, people below 15 years and above 60 years and those with disabilities or acute illness are exempt from attending. So this has to be now enforced in all police stations across India, that women, people of 60 years, people with disabilities or acute illness, somebody may be suffering from cancer or somebody. So these people should also be made aware of their rights.
Yes. There has to be an awareness campaign with regard to it. In any case, I would say that there were not many situations where women in the ordinary course would be required to go to the police station, or a children below or a minor below 15 years or a senior citizen. Usually, who are these persons who would be visiting the police stations? Either the complainants or the persons who are out on bail but they have a condition, or the relatives who want to know about the progress of the case.
Yes.
So now, if you see the overall ecosystem which has been introduced, there will be very, very less circumstances where these persons otherwise would be occasioned to go.
Point well taken. At this moment, now let us listen to what Home Minister Amit Shah spoke in Parliament.
लोकतंत्र में बैलेंस ऑफ वर्क की एक टर्म्स को बहुत महत्व दिया जाता है. आपराधिक न्याय प्रणाली जो अभी हमारे देश के अंदर काम कर रही है, उसमें ये बैलेंस बिगड़ गया था और हमने इसके अंदर बैलेंस ऑफ वर्क का बहुत बारीकी से ध्यान रखा है. अगर मैनेजमेंट के विद्यार्थी इसको बारीकी से देखेंगे, मैनेजमेंट के विज्ञान के हिसाब से देखेंगे, तो उनको मालूम पड़ेगा कि बैलेंस ऑफ वर्क को कितना फाइन ट्यून कर ये कानून के अंदर हमने प्रस्तावित करने का प्रयास किया है. और मान्यवर, मैं आपको और आपके माध्यम से सदन को और सदन के माध्यम से पूरे देश की जनता को विश्वास दिलाना चाहता हूं, इस कानून का संपूर्ण इम्प्लीमेंटेशन होने के बाद तारीख पे तारीख का जमाना जाएगा. 3 साल में किसी भी विक्टिम को न्याय मिल जाए, ऐसी न्याय प्रणाली इस देश के अंदर प्रस्तावित होगी.
Now we'll go back to Senior Advocate Sanjay Singh for his view. There is this whole thing about community service in the new laws. Could you explain about what is community service? Is it replacing certain, has the court got a discretion to waive off your punishment and allow you community service?
You see, in case of petty thefts or public nuisance or say false defamation, the courts would prefer a punishment to be given in the shape of community service.
Right.
Because there are various theories of punishment. And the theories of punishment include a theory of reformation of a person.
Yes.
Or it is not always that you want to teach a lesson to the person.
Right.
Retributive theory of punishment in criminology is looked down upon in the current scenario. We are not really here to take revenge. The purpose of punishment is not to take revenge. It is either to reform a person, to create a remorse in him, or to reform him in some manner, or to prevent him from doing it in future. So there has to be some element of negativity also involved in it. But community service per se is something which is a positive sentiment. So the idea is that if you have committed some minor crime, it is not good to brand you as a criminal and put you in jail. So therefore the better would be that you will have a sense of remorse, because paschatap is something which is integral part of our culture in this country. We have been saying that if that a particular person who committed this sin, for doing prayashchit, he went to such and such place, or he did tapasya for so many years. So what is that? I mean, in our country, in our culture, there is this concept of paschatap. So the community service,
it can be for even grave crimes that you are given sentence of 5, 6 years, 7 years plus community service.
No, not it's not that way.
It's for minor offences only.
For
minor offences only. All in all, if you could give me one final comment on what you think, where are we heading with these 3 new criminal laws?
See, if these 3 criminal laws are correctly and appropriately and quickly implemented, we are certainly heading towards a justice delivery system where the trials will be faster. People who are really the criminals, or those who have committed the crimes, they will be put behind bars and they will be given appropriate punishments in the quickest possible time. And simultaneously, the victims' rehabilitation will also be ensured. In fact, there are provisions which will ensure that there is no victim shaming. Victim will be adequately compensated. Victim, as we have already discussed, has a right to be aware as to what is going on in the matter, etc. So it will create a healthier atmosphere in the country. And if there is a healthier atmosphere in the country where people have faith in the system, then there is a likelihood of the crime rate coming down. Because one of the reasons why the crime rate is higher is this, that the people are impatient, they do not have faith in the system, they feel that the system is acting against them, is totally intricately designed against them, they will never get justice. So therefore they want to take law in their own hand and say that we will do justice ourselves. So if you see the movies of 70s and 80s, this is what the heroes would do. That all right, we are not getting justice, we will do the justice ourselves. So with these laws in place, if justice is achieved, then unnecessarily people will not be tempted to take law in their own hands or to feel frustrated. And if a society is less frustrated, means that society is in that proportion is happier.
Okay.
And if a society is happier, then we have a happy future. And then that energy of the people can be invested in building the nation. So it is not that the nation is built only by a commercial activity. It is equally important that for the building of a nation, that its population lives in peace and happiness, so that they can invest their energy in some constructive and creative form.
Thank you so much, Mr. Jain, for explaining every one of us aspects of the three new criminal laws, namely the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Sureksha Sanhita, and Bharatiya Sakshi Adhiniyam. It was a pleasure talking to you. And to you viewers, we leave you with one final clip of what Home Minister Amit Shah said in Parliament about these three new laws.
बोलने का अधिकार हमारा संविधान का मूल अधिकार है। व्यक्ति के खिलाफ आप कुछ भी बोल सकते हो, कोई गुनाह नहीं होगा, बोलिए। बदनिक्सी का प्रावधान है, जिसको जाना चाहिए वो कोर्ट में जाएगा, मगर आपराधिक न्याय प्रणाली आपको झेलनी नहीं पड़ेगी। परंतु जिस धारा के तहत बाल गंगाधर तिलक, महात्मा गांधी और वीर सावरकर जेल में गए, मुझे आनंद है मान्यवर, आज वो धारा यहाँ से समाप्त हो रही है। मान्यवर, इसके साथ ये कहते हैं कि आपने अलग तरीके से राजद्रोह को देशद्रोह बनाकर लाए। मैं सभी सदस्यों को विनंती करता हूं कि मेरी बात आप ध्यान से सुनिएगा मान्यवर। पहले आईपीसी की धारा 324A में जो शब्द प्रयोग था सरकार के खिलाफ, सरकार मतलब एस्टैब्लिशमेंट और व्यक्ति अंततोगत, अब बीएनएस में धारा 152 में भारत की संप्रभुता, एकता और अखंडता के खिलाफ जो करेगा उसको देशद्रोही माना जाएगा। बड़ा स्पष्ट कर सरकार की जगह भारत शब्द प्रयोग लाए। भारत तो उनको पसंद ही नहीं आता है नाम, मगर मैं क्या कर सकता हूं, ये देश का नाम ही भारत है। मान्यवर, भारत के खिलाफ जो करेगा, भारत की संप्रभुता, एकता और अखंडता के खिलाफ करेगा, उसके खिलाफ ये धारा 122 लाई जाएगी। आईपीसी में उद्देश्य और प्रयोजन की बात नहीं थी, आशय और प्रयोजन की बात नहीं थी। देशद्रोह की डेफिनेशन में आशय की बात कर हमने एक और उसको बचने का मौका दिया है। आईपीसी में जो डेफिनेशन थी उसमें घृणा और अवमानना था, जिससे राजद्रोह का अपराध हो सकता। रानी के खिलाफ अवमानना नहीं कर सकते, रानी के खिलाफ नहीं बोल सकते, रानी को घृणा नहीं बोल सकते। अब हमने क्या शब्द डाले हैं, घृणा और अवमानना हटाकर सशस्त्र विद्रोह, विध्वंसक गतिविधियां, अलगाववादी गतिविधियां और देश के अर्थतंत्र को नुकसान पहुंचाना।
Thank you for joining us and thank you for watching the show. Thank you.